40 years.
Yep.
40 years. Been working on this for 40 years, and guess what? It's happening in Missouri now, and it's really all because of NORML and the people involved with it. I want to mention a couple things about upcoming events. The Mid-Missouri chapter has sort of a social and informational and networking meeting once a month on the first Thursday of the month. And this upcoming month for February will be at Broadway Brewery, and that starts at 6:30. So just come to talk weed, and you know, sometimes we have news to impart, sometimes we don't. Sometimes we just you know, drain a glass and have a good time. Other upcoming events on January 30, we're having a lobby day in Jeff City. There's some legislation, of course. Nobody's life, liberty, or property is safe as long as the legislature's in session. And that's especially true if you like marijuana. There's no less than 8 or 10 bills right now that will affect us or could affect us if they go anywhere in the legislature. With that in mind, this first lobby day early in the session, I don't expect to have any panic going on. I don't get too excited about any particular piece of legislation until it at least gets a hearing, and then I know it's in danger of going somewhere. Other upcoming events, this organization, Missouri Cannabis Industry Association, we have our meetings at Grand Cru. The next one is when, Dan?
Monday, February 11th.
Monday, February 11th at 6 o'clock at Grand Cru. MCIA is also putting on a couple events. One of them is a business seminar that starts at 2 o'clock in the afternoon in St. Charles at the Grand Ole Opry House. It's a minimal charge. I think it's $75 in advance or $100 at the door. There'll also be a networking opportunity, cocktail kind of party thing for people to, and we will have speakers there, including the head of DHSS, Dr. Williams, who's in charge of this implementing medical marijuana completely. Then we're also having a 2-day business expo, April 11 and 12.
12 and 13.
12 and 13, thank you, and that'll be at the Crown Plaza Hotel in St. Louis. To keep track of all these events, I urge you to follow mid-mo-normal, and I think you got to put the hyphen in there, don't you, Lance? Yeah. Mid-mo-normal on Facebook, and what are we on Twitter?
Mid-mo-normal.
Mid-mo-normal.
With a lowercase o.
It's tricky. And then on Instagram.
Yeah.
Also. So do follow us, and that's where we're posting up to the date news on whatever we can find that affects everything cannabis. Is there anybody here who joined mid-mo-normal at Broadway Billiards the last time? Both of you did? See this really cool weed pin on my lapel? Thank you, ladies. I don't suggest you wear those when you're holding, but the attorneys here at the table may have to weigh in on that. With that being said, I'd like to introduce Ben Faber, Dan Viets, and Tom Whitener. Ben and Dan are criminal defense attorneys, and you can tell that because they're both wearing vests. And Tom has some sort of nefarious background in law enforcement. I'm going to be very vague there because he has a job he doesn't want to lose, but he's on our side, guys. So with that being said, I'm going to ask Ben and Dan to flip a coin and talk to us for a couple minutes.
You're welcome to go first, Dan.
Thanks, Dan. So this is a Know Your Rights panel.
You should stand and be louder.
I should stand and be louder. All right, I'll stand and be louder. So thanks everyone for coming tonight. This is Know Your Rights panel. I see a lot of people in here that I recognize who may be more interested in the industry side of things. I don't have a lot of answers in that respect for any of you tonight. Really, what I do is defend people who have already been accused of in some way breaking the law. And what More Normal and New Approach Missouri, Show Me Cannabis, and all these different great organizations have done is they've made it possible for Missourians and actually non-Missourians to, in the state of Missouri, enjoy the use of medical cannabis without breaking the law. So for some reason, Dan Viets in particular has been going really far out of his way to put both of us out of business. But I think it's for the better that people are able to medicate themselves and be free from from criminal liability. So I guess just broadly starting, right? We know now that marijuana is illegal. No one in here is a card holder. Well, does anyone have an out-of-state card as a medical marijuana patient? Okay, so my understanding and my reading of the law is as of December 4th, and 6th, an out-of-state card holder can lawfully possess marijuana in Missouri. Now, there hasn't been any test cases on that yet. We'll see how different prosecuting authorities choose to deal with that. But for the time being, no one in Missouri no Missouri resident can lawfully possess or consume marijuana because no one has cards yet because the Department of Health hasn't rolled out all of the regulations and people haven't been getting cards. Now, if you have an out-of-state license, the constitutional amendment does provide for reciprocity. So that's something to keep in mind. If you have friends coming in from out of town, obviously travel is an issue, and procurement in Missouri is an issue. But the simple act of possessing in Missouri for an out-of-state card holder is, in my opinion, legal, based on my reading of some of the subsections in the constitutional amendment. So I guess the first thing that people want to know when it comes to know my rights, other than is marijuana legal yet, is what happens if I get pulled over, right? Does anyone care to hear anything about that? You, all right, very good. Thanks, Mona. First thing is, if you're in a rental vehicle and you're on I-70, you're probably going to get pulled over for some reason, following too closely, riding the left lane, near the good ones, touching the fog line, touching the center line, things like that. Kind of bogus reasons to get pulled over. Law enforcement has to have an actual good reason to pull you over, whether it's speeding 20 miles over the speed limit or 1 mile over the speed limit. They have to have some good reason to pull you over. So what happens when you get pulled over and law enforcement asks to search your vehicle? Whether you're in possession of contraband or not, you have the right to refuse a search. They're always going to ask you to consent because they don't have to follow any other rules if you consent. We've got the Fourth Amendment kind of protecting us from unlawful searches and seizures, so they can't keep you there roadside for hours and hours or 30, 45 minutes just to talk to you about where you're going, where you're coming from. They have to have some good reason to do that. They have to have some good reason to search your car. They're going to do that, though, without consent based on probable cause, if they want to, right? The number one reason that I see officers search vehicles for probable cause is the odor of marijuana. So that's something to be specifically careful for, is if you think there may have been people in your vehicle that were smoking marijuana or were possessing marijuana, your car may smell like marijuana, then you're probably going to get searched. Or if you look like a marijuana smoker, which different people have different ideas of what that is. I personally don't think that the PIN should give probable cause. The Cheech and Chong shirt, right? Should that formulate into probable cause? But officers will use any number of just different kind of, I think, arbitrary reasons to build that probable cause to search the vehicle, because under it's called the automobile exception, they only have to have some good reason to search a car. Contraband is probably in the vehicle, right? So they'll take things like nervousness, sweating, inconsistent statements about where you're going, where you're coming from, not a lot of luggage in the vehicle, even though it's cross-country, rental vehicle. Recently, there's a case that the Tribune reported on that it's a defense win, but the probable cause was driving with an open mouth and a rigid posture. So be careful, right? I've been in court where this was your case, where Mr. Viets was cross-examining an officer, and he said, "Well, what drew your suspicion to Mr. So-and-so?" He said, "Well, he had his hands both on the wheel and he was sitting up straight in very rigid position." Well, aren't we trained to drive with our hands on 10 and 2? So I guess if you want to not get pulled over, you should slouch and, ride with one hand on the top of the steering wheel, something like that. So in terms of automobiles, you're either going to get searched or you're not. And that's kind of the one thing I really like people to take away from these conversations is, what's the point of all this? What's the point of knowing your rights? And the point of knowing your rights is to assert them, not to really, you don't want to, Tom may have something to add here, but what I tell my clients, or what I tell people like you were here, nice enough to come and visit with me tonight, is you're not going to get anywhere if you're that guy on YouTube, Colombian Pones police officer, with the law, and saying, you can't do this, you can't search me, I know my rights, you can't do that, arguing with them, telling them that they know their rights and all of this stuff. That doesn't get you anywhere. It's not going to get you anything but arrested. Knowing your rights is important because it protects you from the conduct insofar as it gives your attorneys down the line something to work with. Right? So if you consent to a search, we've got very little. We can usually cook something up, but generally if you consent, that takes away a lot of the constitutional safeguards that you would otherwise have. The police are going to do what they're going to do in any case. They're going to arrest you if they want to arrest you. They're going to search you if they think they have a good reason to search you. They're going to frisk you if they think that they should frisk you. And the point of knowing your right to be free from search and seizure, to deny consent, to remain silent, which are kind of the two biggest ones. Knowing that you can do that isn't going to affect anything that they do. So just keep in mind that your duty as a citizen isn't to combat the police or argue with the police or anything like that, but it's just to remain silent and make the state follow the Constitution by asserting these safeguards that you have. So in terms of like car stops, that's I think that's the most important stuff. I didn't talk much about like right to counsel or Fifth Amendment rights, but I think Dan knows a little bit about that. So I'll pass it on to him.
Dan, before you get started, comment on the odor thing. I think reasonable minds, legal minds differ on that, and I hope to hear a lot of conversation about, is the odor of marijuana now probable cause? That's a good question.
An interesting thought to add in that is that Oregon does issue medical cards to Missouri residents. So if you go to the state of Missouri or state of Oregon, Oregon will issue a Oregon state medical marijuana card to an out-of-state resident. So,
And by the way, before Dan gets started again, we will be talking about the implementation of Article 16 and some of the legislation we're concerned about. We'll start in with that about 8 o'clock after this panel is done.
Okay, thanks, Steve. Thanks to all of you for being here. Some of you, I think, picked up these little green cards on your way in, but if you didn't, I want to distribute some of those right now because this is essentially what I want to tell you all. I assert that you already know your most important constitutional rights. Everybody knows, because you hear them on TV and in the movies. Everybody knows you have the right to remain silent as long as you can stand the pain. You have, you guys need anything? How you doing? Now everybody knows you have the right to remain silent, you have the right to an attorney, and anything you say is going to be used against you. And if you think about that in a calm setting like we are right now, the logical conclusion would seem to be that you should not talk. You could remain silent, that's rule number one. If you don't remain silent, they're going to use it against you. And you have the right to a lawyer before you say anything. So I submit that the only thing you should say to a police officer is, I want a lawyer, because every lawyer and every cop in America knows that they're supposed to stop asking you questions when you assert your right to an attorney. They're not going to bring a lawyer to you. You're not going to have a lawyer arrive at the roadside magically. But the point is that every cop knows that he or she is supposed to stop asking questions when you assert that you want to talk to a lawyer. That's why you should say that, but nothing else. And I know it's difficult to do that. I mean, if you're stopped on the highway, and that's where most police encounters occurs, on the highway, you're required to show your driver's license if you're driving the vehicle. You're not required, in Missouri at least, to show your ID unless you're driving the vehicle, but lots of police are just curious and they like to know who everybody is and check whether everybody has a warrant or some other sort of legal matter pending. But passengers are not required to disclose their identity, and pedestrians are not required to disclose their identity. But the most important thing is, once you show them your license, do you know why I stopped you? I would suggest no. I don't know why you stopped me. Even if you think you know, don't help them out. He'll tell you why he stopped you, or she will. But if the conversation seems to be going off topic, if the conversation seems to be leading to things that don't really have anything to do with the reason for this traffic stop, then I suggest you assert your right to remain silent and to say that you would like to talk to a lawyer. You really don't want to answer any questions, and stick to that. It's hard to do. We all think, I can talk my way out of this. I can say something that's going to get me out of trouble, and the odds are you will not. So that's the most important information I think I can impart to you. Use those Miranda rights. Don't worry about whether they've read them to you. Whether they read them to you or not, you already know them. So use them. Don't worry about whether they've been read to you. Cops don't convey those rights. They don't bestow those rights on you when they read them. You always have those rights. And it's far more important that you use those rights than worry about whether they've been read to you, because you already know them. We all know them. You don't have to have them read to you to know that you have the right to remain silent. I just can't overemphasize how important that is. Don't talk to the cops, period. That's rule number one, except to say I want a lawyer. That's the only thing you should be saying to the police. Now, as the little green card here, which we've gone through revisions and edits of these little green cards here for 30 years or so, I've tried to boil down what I thought was some of the most practical and important information for people to know. Never give permission for a search, anywhere, anytime. Don't think, if I deny him permission to search, he'll think I have something. He already thinks that. That's why he wants to search. Don't overthink the situation. Deny permission for a search. If the cop says, you don't mind if I search, do you? The answer is, yes, I do mind. Use a full sentence. Don't allow him to misinterpret your meaning. If he says, may I search? Then the answer is no, you may not search. I do not give you permission to search. That's the only other thing you should be saying in an encounter with the police. Actually, if you say nothing, you're not granting consent to search. Consent is supposed to be clear and unequivocal. Don't give permission for a search. I just can't imagine any situation in which it would make sense to help the police out by giving them permission to search you or your person or your car or anything else. As Ben said, you leave your lawyer with very little to work with. You've given permission for search. You can waive your Fourth Amendment right by saying, yeah, go ahead and search. Don't do that. I suggest, and again, attorneys may differ, as Steve said, on some of these points, but I suggest not opening your door to the police. Don't open your door to strangers generally. Unless this police officer is somebody you know personally and trust, I wouldn't open your door to that stranger. And all the more so if he or she is wearing a uniform and a badge. So many people get so casual that they'll hear a knock on the door and say, yeah, come in. Don't do that. Assume that every knock on the door is the police. Don't invite people in you don't even know. Don't open the door, because if you open the door, much like a Fuller brush salesman, his foot or hers will be in that door. And often they do this just pushing in business. They don't put their hands on you exactly. They just push in. And our natural response, if it's a cop, is to back off, and they will say, I was invited in. They're like vampires. They can't enter your threshold unless you invite them. That's in Bram Stoker's book, and the police are the same way. They are not supposed, we have a Fourth Amendment that protects us like a crucifix, against these vampires. But if you waive that right, if you open that door, you lose your protection. I've never seen a cop break a door down if he didn't have a search warrant. And there's no need to inquire, by the way, officer, do you have a search warrant? If he has one, that door's already open. If he had one, he wouldn't be knocking. If he has one, boom, that door will be open. So there's no need to inquire. It's not like he forgot to tell you that, oh yes, he does have a search warrant. Don't talk to them. It doesn't matter that they know you're in there. That you may say, oh, I'm hiding. I'm pretending there's no one home. It's not pretending no one's home. Saying, fuck you, I'm not going to open the door. Don't say that. Just, don't open the door is important. You open that door, they'll find a reason to come in. They'll say, I smelled a suspicious odor. I saw a suspicious item. Some reason will arise why they need to come in. And once you've opened that door, the courts will let them get away with saying, well, he didn't give me permission to search his home, but I had to secure the home. I had to secure the home and make sure there was nobody else in there. I had to do a walkthrough. I've seen so many police reports where they clearly think they have the right to do a walkthrough and secure your home. Don't open the door. That door is your best protection. Don't open the door. Don't let the gate down over the moat. Don't do that. Your home is your castle. And I don't care if it's a U-Haul trailer or a van down by the river or a dormitory room. You have all the same rights that Trump has in his biggest apartment building. You have those same rights. Don't think, oh, I'm just a little person renting a dorm room here. You have those same rights. If you should see on the streets and highways and byways of our state a temporary sign, typically an orange square sign that says drug checkpoint ahead, well, then you will also shortly after see a sign that says drug dog on duty. And then you won't see a checkpoint, but you will see an exit. And you may think to yourself, what fools these cops are. I can take this exit and avoid them altogether. Don't fall for that trap. That's exactly what they want you to do. Fight against the strong force that tries to make you take that exit. Don't do it. Don't fall for that. Even when you know about this trap, it's sometimes hard to avoid the urge to take that exit. Don't do it. Now, don't litter. That would be the very worst time to litter, because if anything comes out of your window, you can bet you're going to be stopped for littering. That's the only time a cop will stop you for littering, in my experience. But you're under surveillance. You should assume you're under surveillance. And if something comes out of your window, you will be stopped. Don't toss anything out of the window, and don't violate the law. Don't violate more than one law at a time, another wise lawyer I've heard say often. If you're violating one law, whatever that might be, for God's sake, don't violate another law. Don't speed, even a little bit. Don't speed. Don't fail to signal a lane change. That always pisses me off, but that's beside the point. Don't fail to signal a lane change or a turn. Don't speed even a little bit. Don't do a violation that is a traffic law violation. Don't help them. Drive as legally and carefully as you can, and the odds are, well, you won't ever see that drug checkpoint, because it's not on the road ahead, it's at the exit. And when you take that exit, you either have to stop at a stop sign, or you're going to be stopped for some bogus alleged traffic violation. Don't take the exit. Bear in mind that your garbage is fair game. Anything that you put in your garbage and then you set out to the roadside to be picked up, or I'm not sure how dormitory garbage is disposed of these days, but wherever it is that it goes, it's fair game once you have abandoned it. That's what the courts have said. If you put your garbage out to be searched, you have abandoned it. You have abandoned your expectation of privacy in that property of yours. And, most of us don't think we have. I dare say if the judge's garbage were searched, they would feel like their privacy was being invaded. But they tell us we don't have a reasonable expectation of privacy in our garbage. And think about all the information that's in your garbage, in everyone's garbage. I mean, the medicine you're taking, the bills you're paying or not paying, the correspondence that you have, the publications you subscribe to. So the point here is, don't put anything in the garbage that might look or smell suspicious. And keep in mind, drug dogs may be sniffing this garbage. Don't put ashes don't put roaches for God's sake, but don't put anything. Don't put an empty baggie, and don't put a High Times subscription card. Don't put an empty pack of zigzags. Don't put anything that smells or suggests in any way the presence of something illegal. Because what the police will do is search your garbage if they are inclined to do so. They have any suspicion that you might be doing something illegal, or just on a whim, they can go through your garbage with a fine-tooth comb, and they can put a drug dog on that garbage. If that drug dog alerts, God knows, what an alert is, but they only can tell when a dog alerts. If they see a High Times subscription card or an empty pack of zigzags, or God forbid seeds and stems, they'll go to a judge and say, I want a search warrant for this guy's room or home because I found so-and-so in the garbage. Don't put anything in the garbage that you wouldn't want a judge to know about. There are many ways of disposing of garbage other than putting it in, the garbage you're going to set out or allow somebody to haul off. The garbage disposal is an aptly named appliance if you happen to have one of those. The toilet, generally they're not going to be able to retrieve something that goes down the toilet. But don't put something down there that's going to stuff up the toilet. The best thing is just take that garbage somewhere else. Take it to the convenience store. Take it to the gas station. Put it in their garbage, but don't put it in yours. Keep in mind, if you do get arrested, that again, don't answer any questions, but your bond, you're going to have a bond set essentially by the police once you get arrested. If you're facing a misdemeanor charge, you may not even be arrested, and the bond is probably going to be pretty low, meaning $1,000 or so, meaning you can pay 10% of that amount to a bonding agent and get out relatively quickly. But if you're talking about a higher bond, a felony bond of 10,000, 100,000, which is not unusual. I got people facing pot possession charges right now over in Marshall with $250,000 cash only bond. You should give your attorney a chance to reduce that bond, to ask the court essentially to reduce that bond. Bond is not set in stone. You don't have to post whatever bond is first set, and it's very common that bonds are reduced. A cash only bond may be reduced to allow you to use a bonding agent, known as a surety. A court in Missouri very often will allow you to post 10% of the bond amount directly with the court. And that's a great deal because you get that money back, minus fines, court costs, if any. But basically, you get that money back when the case is over with. So you should at least make the attempt and ask the judge, have your attorney ask the judge, would you please let me post 10% with the court instead of paying it to a bonding agent? The money paid to a bonding agent is never returned. They do provide a service. They get you out of jail, and then they hunt you down and drag your ass back to court if you don't show up. That's the service a bonding agent provides. It's a valuable service in some situations, but it's not the first resort. It should be the last resort. You should give your attorney a chance to try to get the bond reduced, to try to get the court to let you put 10% up, and as a last resort, and we hope on a reduced amount, use a bonding agent. That essentially covers most of the points I want to make, and we will allow time for questions later, and I thank you very much.
Tom, did you want to make some comments, or should we go right into Q&A, or Ben?
You mind if I follow up on a couple
Go
things
right
that
ahead.
Ian said? So one thing that I think is important to convey is that this is not a how to not get busted talk, right? This is a know your rights talk, and there may be some people here that some of the things Dan and I have been talking to you about really don't bother you much, right? Like, oh, if they search my car, the worst thing I've got is overdue library book or something like that. But I think it's important for everyone to keep in mind the concept that underlies these constitutional protections we have with the Fourth and the Fifth Amendment, especially with the Fourth Amendment, and that's the right to privacy. So as Americans, you're entitled to a right to privacy. At least that's how the Supreme Court has interpreted the Fourth Amendment, which is to be free from unlawful searches and seizures. And what that means is you've got a reasonable expectation of privacy in certain parts of your life. Your pockets are some of the most respected places of privacy that you have. Your blood, also a very, very well respected place in terms of the law.
But there are vampires out there waiting to take your blood.
Indeed. Your home, also, a very private place, which is why I like to spend so much time talking about cars, because cars are not considered to be nearly as private a place as homes or your pockets or inside of your body. But someone's asked me the question before, why do I care about this stuff if I don't have any drugs on me? If I'm not breaking the law, why not let them search my car, things like that? And it's because you're an American, you have a right to privacy, and like Dan said, police, they're probably most of the time strangers. They're probably most of the time nice people, but they are also strangers, and strangers going through your stuff, at least for me, that's not something I like. If I'm on my way to somewhere, it's going to take a lot longer for a police officer to search my car real quick. They don't usually miss anything. It's very rare for them to miss anything. They know all the places to look. They look thoroughly, and it takes more than 5 minutes. If you've got better things to do than let a stranger go through your personal stuff, then deny consent to search. If you've got better things to do, then tell a stranger where you're going, why you're going there, and where you're coming from, and where you rented the car from, and who you were visiting, and oh, your aunt is sick. Well, what's wrong with your aunt? Why are you asking me these questions? This is none of your business. I don't know you. You're not my friend. Leave me alone. I want to go home. So whether or not you're asserting your right to protect yourself from some sort of criminal liability, or just because you, like me, think it's the right thing to do because it is a right that you have, and there's no good reason to waive it. Like Dan said, I have never seen a case where the police officer said, "Oh, I was just testing you to see if you would let me search your car. Since you've allowed me to search your car, I'm going to go ahead and not search it because no one who would have anything on them would let me search their car." And you might think that's true, but absolutely, like probably 50% of my possession cases are consensual searches. So, you're not going to get one over on them by like playing it cool. So yeah, I just wanted to speak briefly on that. Oh, in terms of the law, right now, and there's some confusion because the way that the Missouri criminal statutes are written, marijuana less than 35 grams is a Class A misdemeanor. Unless it is less than 10 grams of marijuana, this is possession, not distribution, then it's a Class D misdemeanor.
Or infraction. Or maybe
It's
there's
still a D
It's a Class
misdemeanor,
B misdemeanor, and it becomes an A if you have a previous marijuana conviction.
which is what I was
second offense.
getting at, and the reason I brought that up is because you may have, say you have a ticket for having a gram because, you were smoking at the park, and the police said, "Hey, give me that," and you wrote you a ticket, and he was real nice about it. Then you get a summons, and you go to court, and they say $100 fine, and you're like, "Oh, that's it? Okay, $100. Well, guess what? Now you're a drug offender, and if you get in trouble again, then you're looking at up to a year in jail, which, realistically, very few people go to jail for a year for simple possession of misdemeanor marijuana, but you're subject to that, and you are subject to an enhanced range of punishment and enhanced charge by virtue of you showing up to court and paying a little fine for the little bit of marijuana that you had at the park. So, also, you're not entitled to a public defender for a non-jailable offense, which under 10 grams of marijuana is a non-jailable offense. So you don't get a public defender for under 10 grams. So even if you've got the greatest search issue in the world, you're not going to have a lawyer to assert that, and you're always welcome to call Dan or I or any other attorney that you know and talk to them about, well, I don't feel like they should have done this, and I'm worried about my job, I'm worried about, will this go on my record, things like that. So just be really careful. It's very good for like people in St. Louis where they were really mistreating people for these misdemeanor offenses and keeping them in jail for a really long time. But I think it may have had some unintended consequences in terms of denying people access to counsel for small amounts of marijuana where there are enhanceable provisions in the law. And then, of course, anything over 35 grams of marijuana or any other drug, which includes THC currently, is the way that most, not all courts interpret the law, but I think reasonable minds can disagree on whether THC is or is not marijuana. And by THC, I mean concentrates, oils, waxes, shatter, things like that. Anything that's not marijuana flower is subject to a felony charge, so cocaine and prescription pills that are scheduled and the other marijuana byproducts that I was alluding to earlier, all those things can be charged as felony offenses, so be careful. And Tom, or Dan?
Can everybody hear me pretty well? I got bad knees and I'll have to stand all day. So, two things I'm going to preface what I'm going to say is, one, no, they don't have anything better to do. Okay, that's the real answer is no, they don't have anything better to do. And second of all, there are really good cops out there. Some of the best dudes I know, some of my best friends in the world are cops. They're more few and far between than you'd hope to think, unfortunately. If I learned anything from my time in law enforcement, it was that I hated about 80% of the people that I worked with more than I've ever hated anyone in my life. I found that the criminals were at least honest about the fact that they were being criminals and that they didn't like you and that they were going to do this thing. And too many of the officers I worked with did horrible things under the guise of I'm doing the right thing for my community. So a couple things I like to get into is these civil rights fights. Understand that when you contact a law enforcement officer on the street and you're pulled over, if that officer's doing something, you're not going to prove to them that they're wrong right there on the street. If they're doing it, they believe that what they're doing is both right and lawful. If they're arresting you for marijuana and acting offended by the very fact that marijuana exists within your vehicle, understand that they're doing so because for years, in some of these cops' cases, decades, they've been taught that marijuana is a horrible, life-ruining drug. I think if you want to sum up the amount of knowledge about marijuana in our communities, a news agency in Texas did a story about marijuana last month, and their stock photo was a lighter under a needle. That's how little they knew. So if a cop stops you, whatever he's doing, he believes, right or wrong, that what he's doing is both lawful and moral. So when you get into these situations, there's a difference between compliance and standing up for your rights. Be very clear about not consenting to a search. Absolutely don't consent to a search. Don't consent to a frisk. Hey, do you mind? One thing that'll get you is the, hey, do you mind? Yes or no is how you say yes or no can be interpreted as yes or no. Always make your answers very clear with an officer. Hey, you mind if I just check your car real quick? On my field training, I was taught to never ask to search a car. Is there anything in your car that's illegal? You mind if I just check real quick? Right? And even a nod indicated that consent. Okay? And what I was always taught was that starts the time clock. Your nod starts the time clock because as I get closer to whatever's illegal in your car, you're going to revoke that consent. So the idea being is to establish probable cause for that consent search immediately. Look for that flake of weed, look for that seed, look for that roach, and then now you've got probable cause. So never consent, and make your lack of consent very clear. I don't consent to any searches of my vehicle. I don't consent to any searches of my person. I don't want you searching my pockets. I don't want you to frisk me. And I think another important thing to know from a activism point of view, I think all of us are here through some level of belief of civic duty about protecting ourselves and protecting the people in our community from unlawful searches and seizures and from general government abuse, which I think has become far too rampant at this point. One thing I'd say is that this fight is never won in the street. You're going to be tried, if you get arrested or if this is a case, it's going to be tried in two places. It's going to be tried in the court of public opinion via Facebook, video, and YouTube, and it's going to be tried in a court of law. No matter how right you are, if you fight the cops and catch another charge, if you're cursing at a police officer and calling him an asshole on camera, that doesn't make you look good, and it certainly doesn't give credence to the side of government overreach and abuse of power. So, your best bet is when you find yourself in those situations, as eloquently and calmly as possible, absolutely stand up for your rights. No, I don't consent to the search of my vehicle. No, I don't consent to the frisk of my person. Even more importantly, hey, I want to check your pockets. Why? For my safety. That's not reasonable suspicion, sir. But understand that if he goes to frisk your pockets, he's going to do that because he believes that he can. And if you resist, there's no win about getting beat up on the side of the road. It doesn't work that way. You want to put yourself in a position where you've asserted your rights under the Fourth Amendment. You've asserted your constitutional protections in a manner that doesn't reflect poorly upon you and gives ample opportunity for a good lawyer to take the case to court. Not only because that's where you really win is to get a case dismissed, but because that's where we all win as a whole. If a cop pushes that boundary, it's no longer about you winning, it's about us as a whole, us as a society winning. A cop's not gonna push a boundary one time with you. Remember that you're not special. If he's pushing that boundary with you, he's been pushing that boundary for 5 years. He's been pushing that boundary for 10 years. And he's gotten away with it for 5 or 10 years. And he's pushed that boundary because he works for an agency that allows him to push that boundary. He's in a jurisdiction where the prosecutor's office allows him to push that boundary. And when you're the one that says, listen, I don't feel comfortable with this search, I want to make it clear to you on camera that I'm not consenting to this search, and you take it to court and with a decent attorney and you win that, not only does it win that case for you, but it sets a precedent in that area. Sometimes it sets a precedent in the state. Sometimes it goes to the Supreme Court and sets a precedent for the entire United States that says, this is behavior that we find questionable that will no longer be tolerated by law enforcement. You know what I mean? We're no longer going to allow cops to do these certain things. Is it Massachusetts that no longer allows? Mm-hmm. Massachusetts no longer allows the search of a motor vehicle based off the odor of marijuana. I think we'll maybe tackle that a little bit more here in depth, but it's important to remember that there is no winning an argument against a police officer on the side of the road. There's no winning resisting arrest. The simple fact is they're going to do what they're going to do. Your job is to, as eloquently as possible, assert your rights and constitutional protections. All right? It is to defend yourself verbally when you need to. And if the situation devolves, if they search your car, if you go to jail, your job is to fight that in court, as you're lawfully allowed to do, and use the legal remedies that are at your disposal to show the government that their overreach is not welcome in our community, and that if they overreach, if they do things they're not supposed to do, that we as citizens are going to stand up in the courts and set a precedent that we're not going to walk on.
Let's talk about the odor of marijuana for just a second. I'm kind of fascinated by that being considered no longer probable cause. And what's your theory on that, Tom?
So here's my argument. Up until now, nobody in the state of Missouri has been allowed to own marijuana, period. Nobody. So if you smell weed in your car, automatically probable cause to search. Here's the thing. You're not the best at hiding things. Everybody thinks they are. You're not the best. We know that your dash light pops off. We know that your ashtray comes out of the dash. Okay? And unfortunately, odor of marijuana is pretty hard to prove. So if a cop says they smell it, the courts have generally just found that they believe that. So the idea being that no one's allowed to own marijuana. Marijuana is automatically probable cause for a search. I would contend now that if even one person has a medical marijuana card, even one person, and even one person in our state is allowed to own medical marijuana, is allowed to smell like marijuana, my idea would be it's no longer probable cause. Now they no longer know whether or not you've committed a crime. They simply know that you may have committed a crime. You have something that might be illegal, and in turn it might be completely legal for you to have. And so now the only threshold they've met is maybe reasonable suspicion. The way I'd like to see it play out is an officer smells the odor of marijuana, search the car based on it, hook somebody up for marijuana, and when we get to court, a proper argument is made. Did you know whether or not the person had a medical marijuana card? And when the officer can't articulate that they knew whether or not that person could lawfully own marijuana, then we allow the courts to determine that odor of marijuana is no longer probable cause. It's reasonable suspicion at best, and reasonable suspicion is not good enough to search a vehicle.
Let's ask the guys with the vests. What do you think?
Dan, is there anything in the amendment that requires an individual to furnish a patient card on demand, whether or not they're in possession?
No.
So that, I think that brings into play what Dan was saying about keeping your mouth shut. Because if this officer asks you, hey, do you have, are you a licensed medical marijuana patient? And you say, no, I'm not, then I think there's probable cause.
Mm-hmm.
But if you say, yes, I am, then maybe there's not. Maybe you're lying, but if you are, then maybe there's not probable cause. But I think you can also just say, are you, officer? He says, well, why are you asking me? Why are you asking me? We're not friends. We're not talking about our personal lives here. This is a traffic stop. Give me a ticket. I want to go home.
I would maybe recommend I don't like to discuss my medical issues outside of my medical professionals.
Probably take his advice. His is better.
Believe it or not, contempt of cop is still a very real thing.
Right.
Shall we go to questions, guys, or did you have some other
Yeah,
points you
if I
wanna
can make a couple of points that what Ben and Tom have said has brought to mind. It's very tempting now to go to court with a simple possession, small possession case. Sometimes the judge will say to the prosecutor, are you asking for any jail time? Or if it's a first offense under 10 grams, the judge knows there's no jail time possible. Not only can you not get a public defender, but you may be invited, just go ahead and plead guilty. They'll just offer you a fine. Well, keep in mind, if you pay a $1 fine, you have a permanent public record of a drug conviction. And every lender, every landlord, and every employer you apply to for the rest of your life is going to see that. It's really easy now to find everybody's criminal record. The public part of it, at least, is on case.net. So I really recommend not doing that. There are, of course, far more arrests for simple possession of small amounts than any other related offense, any other marijuana related offense. I do recommend that you get a lawyer because almost invariably we can get an outcome that won't leave you with a permanent public record. I say permanent due to a law that just passed the legislature a couple of years ago, went into effect in January of last year, and I helped write and pass. You can expunge convictions, but only after 3 years from the end of your probation on misdemeanors and 7 years after the end of your probation on felonies. You're far better off getting a disposition, a suspended imposition of sentence that will leave you with no public record automatically as soon as you're off probation. So don't fall into the trap of thinking, oh, I'll just pay a small fine and be done with it. You won't be done with it. It is the most remarkable thing that's come about since the passage of Amendment 2 in November of last year, which got more votes than any of the half dozen other issues on that ballot, more votes than any other statewide candidate for office, more votes than McCaskill, more votes than Hawley, more votes than anything or anybody, is that some prosecutors have taken note of this. And in the city of St. Louis, and in St. Louis County, and in Jackson County, the 3 largest jurisdictions in the state of Missouri, prosecutors have announced they will no longer prosecute marijuana possession. Up to 100 grams, not just misdemeanors, but felony possession amounts, 3.5 ounces basically. And we hope to persuade the local prosecutors to do likewise. That hasn't happened yet, but that's an amazing consequence. Finally, one of the tactics I've seen more in recent years is officers saying to a suspect, just be honest with me. You know, they're trying to get you to talk, and they say, just be honest with me. Well, the implication, how can you be honest if you're not talking? You know, well, the only response you should make is, I honestly want to talk to a lawyer. You know, be honest about that and stick with that.
Robert?
So one of my biggest fears is
Would you mind standing?
yeah, no problem. One of my biggest fears is with the police and like us when they pull you over or whatever, is the education of the medical marijuana card, or with medical marijuana being legal now, because with the Second Amendment, these officers have failed miserably. I'm an avid gun owner for sports protection, whatever you want to call it. And I've had my guns taken illegally. I've had them put in my trunk 3 times. Oh, just put your gun in your trunk until I pull off. I've had this stuff happen before, so I just think that there needs to be some training with this stuff coming up real fast.
Let me weigh in on that if I could. I don't know if it's a matter of training. We've got this catch-22. We've got this thing going on in our country. We've got a federal law that's conflicting with state laws, basically. And the whole issue about firearms and medical marijuana, and if there's a conflict there, yeah, there probably is one. And if a cop wanted to be a real jerk about it, he could probably get away with it. We're trying to deal with that somewhat. There is a bill in the legislature right now that would prohibit any state agency from communicating to any federal agency the fact that you've got a medical marijuana card. We also have suggested rules to emphasize, even though your medical marijuana card, I argue, and even Dr. Williams, I believe he agreed with me, that your medical marijuana card, the existence of it is information that's protected by HIPAA, just like any of your other medical information. And so with that in mind, the fact that you've got a medical marijuana card, like I think it was Tom, or one of the guys up here said, I don't want to discuss my health issues with you. I don't know you. You're not my friend.
Well, I wanted to make sure that you understand that I'm not talking about the two together. What I'm talking about is that as our gun laws have changed over the last, just say, 10 years, our laws for firearms have changed. I've had those incidents because the police officer did not know the law.
You can then call a lawyer. Unfortunately, you call a lawyer about getting your gun back that they took, or you want to sue them or something. There's so many levels of immunity for law enforcement. How much time do you want me to spend on this? And what that means is, how much money do you want to spend on this? And when you're talking about a $400 pistol, or even a more valuable firearm than that, a lot of people have thrown good money after bad on principle. But short of seeking some sort of civil action against the state for this violation of your rights, like what Tom said, these things are they're fought and won sometimes in the court of public opinion. And going a quick search online, you can find local advocates who you can tell your story to, and they can maybe bring some publicity. There's a civil police officers review board.
It depends on your jurisdiction.
I can't remember the acronym for the Columbia one, but there's places to file complaints and just do everything you can. Unfortunately, there's nothing that you can do affirmatively in the moment to keep them from doing things that you don't like, and there's very little you can do long-term to hold them accountable other than casting a vote.
Well, again, the real reason why I brought that, I kind of wish I hadn't said anything about the guns, because I'm not really talking about the guns and marijuana together. I'm talking about the police just not knowing.
Well, the same thing is
laws.
going to happen with marijuana,
Right.
I think, and I may be wrong, but if they don't think your card is valid, or they think that you obtained your card by fraud, or they're not sure that this concentrate, this thing that you're saying is a concentrate. Well, you're saying
Most
it's
of them
THC
don't even know what concentrate is.
Right.
They think it's heroin when they see it.
Right. So, how do I know that this is wax and not heroin? I'm going to seize it and lab test it, and guess what? You're never going to get it back, because I have a case right now where they seized my client's, I believe, lawfully possessed marijuana, because she's got this out-of-state card. And so, what do? Do we get it back? Do we ask the police to give her the marijuana back? And what kind of liability do they have federally for distributing drugs at this point? I mean, so there's a lot of weird stuff that happens, and not a lot you can do about it, okay, other than documenting, to some extent publicizing. And I think all the things that I mentioned to you about guns, I meant to add, we're going to see the exact same things with marijuana, things we don't like happening. And the only way to do something about them is to address it in court later on, in the public sphere, or with leadership and politics.
I think an unfortunate thing is there's a level of lawful harassment the police can dish out. You get stopped 6 times in a day, as long as they've got a traffic violation, they can do it. And the reality is that some of these cops for 20 or 30 years have been taught that their grandpa's grandpa taught them that the devil's lettuce was the worst thing that's ever going to happen to this country, and they saw reefer madness. And so it doesn't matter what they're taught. They're going to do what law enforcement has been doing for the past 30 or 40 years, unfortunately, which is finding ever more clever ways to not violate the Constitution, but to circumvent it entirely. And so I think what you're going to find is, I'll put it this way, I would absolutely bet my next year's salary, I'm not going to say their names of the department, I could absolutely bet my next year's salary that I know of 2 cops at a local department who are going to sit outside of the first dispensary that opens and stop every single car that leaves for some reason. Guarantee it. It's ingrained into their brain for 20 years that the devil's lettuce is the worst thing to ever happen to this country, and that only bad, as Jeff Sessions said, good people don't use marijuana. I would contend to Jeff Sessions, it's been a long time, but I'm a decorated combat veteran. I've received an award from the governor of Missouri for heroism in law enforcement. And I think if maybe I go get a medical marijuana card when it's illegal, that doesn't make me a bad person. But they don't see it that way. You know what I mean? So understand that you're going to fight a lack of knowledge about the Constitution and a lack of knowledge about your rights. And also, quite frankly, a lack of them caring about your rights, which is sadly a bigger issue and a much more difficult one for us to tackle.
Any more questions before we move on to implementation? Yes, sir.
It's regarding the search and seizure and the rights. Is there any variable between juvenile and adult? Are there any differences in your rights or procedures? Is it all across the board the same? I have 2 teenage sons, which I've expressed a lot of the same information to, about how to appropriately handle themselves. So,
The juveniles have the statutory right to be read Miranda, I believe,
okay.
where adults don't. Adults don't necessarily have to be read Miranda. There can be other. It's complicated. The Supreme Court has kind of eviscerated the meaning of the Miranda warning, but I believe that there's a statutory requirement that law enforcement
We can't
affirmatively Mirandize a child and tell them that they can speak to and they may add in parent.
I can't interview as a law. If I were a law enforcement officer acting in that capacity, and you can't even say I arrested a child. If you detained a minor, you could not question that minor regarding the crime. In many jurisdictions, it requires both a deputy juvenile officer to be present and now that doesn't involve traffic offenses. If your kid gets pulled over and they ask, were you speeding? That's fine. But
Right.
Miranda for adults requires 2 things: custody plus interrogation. So you have to be in custody and they have to be asking guilt-seeking questions for Miranda to be required. For kids, it's generally the same thing, but the difference is that a kid can't consent to the interview, and a kid can't say, hey, I understand my Miranda rights and I consent to this interview, I consent to answering your questions. It requires parental consent to conduct the interview. So
The Supreme Court said in a famous decision that students, and they were talking about high school students, do not shed their constitutional rights at the schoolhouse gate. But ever since then, they've been proving that's wrong. And in the Fourth Amendment, that's the First Amendment, but in the Fourth Amendment context, the Supreme Court has held that students have a reduced expectation of privacy, I guess, because they will allow random drug tests of high school students. They will not allow random drug tests of college students. If you reach the age of 18, then your full constitutional rights are in play. I think it's correct that they do have the same Miranda rights, certainly, and again, they don't have to wait until they have them read to them. They have the right to remain silent, they have the right to an attorney, and that's the most important thing they should keep in mind. It's just so immensely important not to talk to the police. They will misconstrue, they will misremember what you actually said. The more you say, the more they'll remember things you didn't say, but they'll swear you did. Don't talk.
the most accurate thing a police officer will ever say to you are the words that anything you say can and will be used against you in a court of law. It'll happen.
There's a question over here. Yes? No? There it is.
So regarding like possessing in my home or something, does renting a place, do you have any different rights compared to if you own your home?
So one weird exception cops are going to use, right or wrong, I don't know that it's been challenged in the Supreme Court yet, is if your lease contains some clause about walkthrough by your landlord, any information your landlord gathers during that walkthrough can be used by the police to get a search warrant. Yeah. So just remember that. If your landlord comes in to fix your pipes, and as long as he's within the confines of that 24-hour notice or whatever that he decided to give you, and he sees your pot plants growing in a closet somewhere, he'll tell the cops.
He can tell the cops about it, but he can't give the cops permission to come in. And a lot of landlords think otherwise. A lot of cops think if the landlord says I can go in, I can, but they can't. And I've won cases on that point, so, for what it's worth.
Have time for one more question at this level before we move on to other things we eat. Yes.
If I had an out-of-state card, can I start growing my 6 plants right now?
It's a good question. Dan?
If you have your patient card,
Yeah.
yes.
I'm
At the
currently
same
a
time,
California resident. So
Sorry?
I'm currently a California resident.
I mean, like, technically, I still
Right.
have a California,
No,
I still have a Cali ID, so.
I don't think the reciprocity would apply to you growing in Missouri. But as of the 5th of July, when you can apply to become a patient, you can also apply to become a patient cultivator at that point. I think it's $25 to be a patient, $100 to be a cultivator. So, file both those license applications at the same time. But I don't think you have a defense yet for cultivation, even if you have a card from another state.
And for possession, it would have to be a med card
Yeah.
from California.
Just
Not even
a-
the physician certification.
Yeah, that's what I'm talking about, like the doctor's Rick, like, I could easily get that.
If you have a signed physician certification letter,
That's one of the great things about Amendment 2. We've used the term qualification and qualifying, a qualified patient or a qualifying letter. The only thing that a physician has to say is not that they recommend the use of marijuana, not that marijuana helps you, but only you have been diagnosed with one of the conditions listed in Amendment 2 or another medical condition. That's all they have to verify. They don't have to, and I think a lot of doctors don't understand that yet, and a lot of us even have said in the past, oh, you need a recommendation, but you don't. You just need a letter that states that you have a condition, either one that's in the amendment explicitly or another medical condition.
And as of right now, it could be changed by regulation. That certification from the physician that says you have a condition doesn't even have to specify which of the listed conditions in the amendment that you have. Just says you have one of the ones listed, which there again, it increases the privacy level.
I think that's true.
Okay, Ben, you needed to take off. And we'll keep our weed experts here at the panel, and we'll start talking more about Amendment 16, which may be Amendment 14, we're not sure.
Thanks.
I mentioned we're not sure if it's 16 or 14 because we had a little meeting before this, and we were looking up the reviser of statute is the place where the holy books for Missouri are kept. He is the one that decides what's in the set of books that is the Missouri statutes. And so we looked that up while we're sitting at the table, and it showed our Amendment 2 as Article 14. Well, that would be a problem. What we think is the reviser statute mixed up the Roman numerals.
Yeah.
And instead of XVI, he had XIV. So that may be something we go and tease him about on lobby day. I had mentioned, or Dan had mentioned, that I've been working on suggestions for regulations as part of my involvement in that organization. And of course, it leads over into my involvement in NORML as well. We've had 2 meetings in Jefferson City. The first meeting, well, 3, I guess. The first meeting was with Dr. Williams, who's the head of DHSS. He is a physician, he's an OBGYN, and he really focuses on patients. And he also focuses on the Constitution. He was very explicit with the fact that I'm going to follow the Constitution, which is the changes we made, and he made it clear that he's a patient advocate, as you might expect from a physician. The next meeting was with Lyndall Fraker, who has retired from the Missouri House and is now the director of medical marijuana for DHSS, in other words, directly under Dr. Williams. We also met with his staff attorney, a young woman by the name of Amy Moore. And something that happened during that meeting made me feel really good. The conversation was something about how MCIA is really focused on patients and availability and safety, and she said that's our North Star. It's up on the wall in my office. So I really appreciated hearing that, because from the beginning, what were we about? You know, we were telling the public, go to the polls, this is about patients. It's not necessarily about getting high and partying. At this point, it's about medical marijuana. And DHSS, Division of Health and Senior Services, they've really taken that to heart from what I can tell. So I felt that the focus of the committee with the individuals with whom I was working should be just that. And the instructions were to go through the regulations from other states and look for unintended consequences. Look for things that maybe were missed, and what are your and envelop that around your concerns. And we ended up with at least 35 different suggestions, which I took recently down to Jefferson City and met with Mr. Fraker. Some of the ones that I think are really most significant of the 35 from the patient advocacy point of view, and from the other focus is for the small player. You know, we've all heard stories about, oh, you got to hire this law firm, that consultant, it's going to be $250,000. The application's going to be 500 pages long, and you're probably not going to get a license unless you spend all this money with consultants and so forth. And I'm sure if you spend $250,000 with an experienced law firm who's done licenses before, that's going to help. For some reason, that just didn't seem fair to me. For the guy who's got, 20 acres and wants to grow some marijuana. So one of the things I learned talking to people from other states, in Oklahoma, their regulations said any attachment to any question on the application can be is a maximum of 5 pages. So that enables, any one of us to do the application our own. And the woman I talked to who had a dispensary in Oklahoma, she did the application on her own. She got a license, and she said something to me that was interesting. She said, because I did it myself, and because I had to digest the regulations myself and study them in order to fill out my application, I know what I'm doing now, and I'm going to run my dispensary so I don't lose my license. Some of these other people that rely on other people to do it for them, well, they're probably going to screw up and get fined or lose their license or something else if they don't really know what's in the regulations and they haven't studied them. And believe me, that like Colorado regulations are 279 pages. It's not a page turner, I'll tell you that right now. And of course, I've been studying those in other states as well. So I think that's one of the best suggestions I took down to Jefferson City among those 35. And then there's some other, couple other things. In the amendment, there's a 1,000-foot restriction on how close a marijuana facility can be to a church or a school, and describes the facilities that are protected from having these evil institutions so close. I explained to Mr. Fraker that this is probably a throwback to liquor prohibition, when you didn't want drunk people going to church or whatever the reason was, and he actually repeated that back to me later on during the conversation. That made sense to him. So I said, well, we wrote, our RPO. I didn't write it. Dan and some other people smarter than me wrote it, and put that in there because they knew that this was probably going to be something that the haters, if it wasn't there, that they would latch onto. So I said, well, we're living with it. It's in the Constitution now. So let's think of a regulation that will soften it somewhat. And the idea we came up with, or that I took to him, was to measure the distance by how you would walk or drive. Up this block, down that block, instead of like a beeline through the structure somewhere. And that might help, because if you can picture downtown Columbia, we'd like to have a dispensary down there somewhere. Where are you going to be where it's 1,000 feet? Now, I believe, Dan believes, told me this, learn something all the time every time I talk to Dan, that municipalities can waive the 1,000-foot restriction. And that could happen in Columbia. Our city council, you may or may not be aware, about a year ago, I think it was, unanimously passed a resolution with the whereases, and now here it's resolved that the city of Columbia endorses the legalization of medical marijuana and the ability to grow medical marijuana at home. So we are in a friendly environment here, and that's something else that the regulators are going to look for when they're giving out licenses. They may not give a license to somebody that lives in a community where the city ain't going to allow it. Columbia, I don't think we're going to have that problem. Other suggestions I took with me. One of the demographics that benefits from medical marijuana the most are children with epilepsy. But in most states, regulations I read, there's this blanket prohibition about having medical marijuana anywhere near a school. So I wanted it clear in the regulations. I mean, school nurses give out all kinds of drugs that they're allowed to give. You know, the kid has to have a dose of, you know, whatever he's taking during the day. It's a prescription drug, they can hand it out. I want to make it sure that there's not an unintended consequence, that child can still. Now, it may not be smoking a joint in school. It may be that he has to use an edible for his medication at school. But, you know, that's fine, as long as those people, and other shut-ins. In my suggestions, I've put, if you're in prison and you need medical marijuana, you should be able to get it there. A big concern is, what about people who are incompetent or in nursing homes? Let's make sure that there's no unintended consequence in the regulations that make it difficult for them to get their medication. If I have a relative with dementia and has no ability to apply for a medical marijuana card themselves, we need regulations to allow for that and to allow for that medication to be administered. I mentioned my concern with HIPAA before, and that was one of the recommendations, that even though we believe that the existence of your medical marijuana card is covered by HIPAA, somebody with a dispensary may not realize that they're subject to HIPAA, and they don't have a hospital or clinic. They're not familiar with HIPAA regulations. So let's put that in the marijuana regulations, that medical marijuana is a HIPAA, comes under HIPAA, so that the dispensary owner who reads the regulations that apply to dispensary owners will go, oh yeah, I have to make sure I comply with that. We mentioned renters. Dan, I'd like you to weigh in on that, on what our fears are about renters and landlords and people prohibiting the growing of marijuana in your apartment when you can grow a cactus if you want.
Well, it's governed by the lease. I think a landlord has the ability to put into his lease or her lease that you can't grow anything, probably. I mean, they can certainly say no candles, no incense, no fire, and I think they could probably legally prohibit cultivation of plants in general. I don't know that they couldn't say no cannabis plants in particular. I met with a bunch of Columbia realtors back before the election, and they were very concerned that the courts may order them to accommodate medical marijuana patients and order them to allow cultivation in their apartments and certainly to allow smoking in their apartments. But I think their fears are not well-founded. I'm not aware of, and I had some research done on this by somebody who's much better at it than I, and she didn't find any cases that have held that anywhere in the country. There may be some, I'd like to know about it if there are. But the landlords couldn't really show me this case. They all think there's such a case, but they couldn't tell me the name or give me a citation. I just find it unlikely that Missouri courts are going to order landlords to accommodate patients and allow either smoking or cultivation. But of course, more and more patients are consuming cannabis in the form of edibles. And I can't imagine any prohibition on edibles. And, you know, vaporizing may be a gray area. But vaporizing obviously also is becoming much more popular, and may already be more popular than smoking anyway. So, you know, I think there's a way to accommodate the needs of patients who may live in an apartment that doesn't allow smoking by at least using edibles, or perhaps by vaporizing.
Thanks, Dan. One other that's a major concern to people who plan to be home cultivators is inspections. And here, you know, this sort of dovetails with what we spoke about the first hour. And that's, you know, you don't want somebody coming to your door saying, you've got a license to grow 6 plants. I'm coming into your house right now during your dinner time, and I'm going to look around and make sure you're not growing more than 6 plants. We don't want that. And my suggestion to DHSS about inspections of home cultivators is that you can be inspected by appointment only unless there's probable cause. And I really, that's going to be one that when the first set of regulations get published, probably pretty soon, believe me, we're going to be all over those regulations looking for those kinds of things, and if they're not, they're fighting for them, because, you know, we do have priorities, and I think that's a very high priority.
Do we have a firm date on when the regulations will come out?
Yes and no.
Remember, it's a government operation.
A lot of it is, you know, a lot of.
Did you pick up one of these?
Yeah.
Okay. One of the things I apologized for, when did I go down there? Last Tuesday. One of the things I apologized for, because I was there on the 17th of January, and the 18th of January, according to this, is when the internal vetting and revision of rule drafts was to be completed. So I apologized. I said, I'm sorry I'm getting this to you so late when you're going to be finished tomorrow. And he said, this timeline was put out before I was hired. So you can take from that what you will. So as far as when those are available, they've got a deadline here, February 22 to May 17, external evaluation for finalized rules. Don't know what that means, other than on February 22, we should have something to look at. And
I think they have to allow 60 days for public comment. They have to publish the final regulations by the 4th of June. So somewhere between February and April, I think April is the latest they could publish them and still allow a 60-day public comment period and finalize them by the 4th of June. But that's the agenda they're held to. If you look at the timeline across the bottom of this sheet, these are the deadlines that are imposed by the Missouri State Constitution, Article 16, we believe. And so again, they'll begin accepting patient applications on, they say the 4th, but they mean the 5th of July. They'll begin accepting applications for what they call facility license, and that means all the commercial licenses, on the 3rd of August. But their deadline to approve those commercial license applications is until the end of the year. So, you know, we hope they're going to approve them sooner, and they want to move the program forward quickly. I think the odds are pretty good that they'll issue at least some of those cultivation licenses well before the end of the year. But obviously, it's got to be Missouri-grown marijuana that's sold in the Missouri dispensaries. We've got to have enough patients licensed to have customers for those dispensaries. It's going to be sometime, most certainly, after January of 2020 before we're likely to have dispensaries selling cannabis.
So let's say I apply for it and get a cultivation license. My initial stock,
Right.
how am I supposed to be able to get there?
That's the immaculate conception.
Or the chicken and the egg. And we had this discussion last Tuesday, and I offered how different states handle it. And I did have on the phone an expert from Colorado to weigh in on some of the conversation. And this person is familiar with regulations and the way it actually works all over the country because he is immersed in the business. And the way it's usually handled is at a startup state, it's don't ask, don't tell. Oklahoma formalized don't ask, don't tell by saying you have 1 year from the date you get your license. We're not going to ask you where you got your genetics from. And then you have to start going seed to sale or whatever the terminology is. I think overwhelmingly it's the don't ask, don't tell in all the states. Oklahoma's the only one I know that
The
formally.
advisors that I talked to in Colorado said basically they just kind of turned a blind eye for a specific time period.
Right.
But that's another reason that we're here. We're getting ready to go to Denver this weekend and trying to pick up some information there from people that have been in the business for 5, 10 years to look at the integration of the businesses and everything. And in talking to the advisors there, they want a massive amount of money to fill out these help you get an application.
What kind of numbers you're hearing?
$100 grand is what I've heard from one in California and one in Colorado, and that's no guarantees. And that money, just like the application fee, if you don't get the license, sorry, too bad. If you do get the license, then we're gonna either A, charge you a winner's fee, or we're gonna take B, a percentage of your business when you sell.
Ooh, okay.
2%. So, I've heard varying things, but what I'm concerned about, they're saying, okay, these things should be 500 to 1,500 page long applications, which would be obviously a little much for a regular guy to go through. That's where I'm hoping this guy might come in. But, we're trying to figure out how involved do we have to get into that consultancy, or is this something that we're gonna be able to, do in good faith on our own?
If it's unlimited, if this 5-page thing gets, or something similar gets into the Missouri regs, I'd say, damn the consultants, full speed ahead.
I don't wanna put that kind of money.
Yeah, I'm glad to hear that because that opens it up to mom and pop operations. It should
Yes.
only be big corporations.
That's
and
exactly what
rich
MCIA
individuals who have opportunity in this industry.
And that's exactly what MCIA is all about, is making sure that it's not just the big money interests to take over. And DHSS, I think, is sympathetic to that.
That's good, because we know big pharma and all the and cigarette companies are also already got their hand in the game and it's coming, so.
Do we know what we're gonna do for banking in the state of Missouri?
No, but at the MCIA seminars, there will be somebody there talking about 280E and how to structure your business.
Right.
So that as much of your expense as possible is tax deductible.
Yeah.
Yes, Robert?
I'll just say, understand that GlaxoSmithKline, the pharmaceutical company, has a full-time rep doing marijuana on Missouri's Capitol Hill right now. I actually know the dude. Has his full-time job right now for GlaxoSmithKline is to rep that pharmaceutical company at Missouri's Capitol for medical marijuana.
I would suggest everybody that's interested in getting in this business to join Missouri Normal, as they've said, and MCIA, as I've done, because that may be the only money you need to spend to get the stuff you need to do the paperwork on your own.
And, keep in mind, they're gonna be, and in the amendment, there's a list of things that they're looking for, but you should be sure there's somebody on your team who can do IT, who can do compliance, who can do, what are your plans for green waste disposal? What are your plans for security? Do you have somebody on your team for security, or do you have a relationship with a security company? All those things that they're looking for, you want that in your application. And I mentioned before, the local political climate. I tell everybody who wants to a license in Columbia to attach that resolution from the city council. More questions? Because they kicked us out of here 1 minute ago. Go ahead.
Do we need to apply or have another license to personally cultivate those 6 plants that you have in that one?
That's $100 a year fee. Yes, you do have to register to grow your 6 plants. It's a $100 annual fee. You can also grow 6 plants for 2 other people, 6 and 6, so 12 more plants if you are their caretaker for growing for them. They have to have their medical marijuana card and establish a relationship with you, so that you can grow for them as well.
That's under that $100 application.
And where do you apply at?
Those applications have yet to be invented in Jefferson City.
June 4th, they'll be published, at least by June 4th.
On the state website?
On dhss.mo.gov.
And I can't imagine that those would be limited in any way, shape, or form.
No, they won't.
Right. And there are, there will be some security to comply with. If you're growing at home, it's gotta be, locked and so forth. So, anything else before they throw us out of the library? Yes, sir.
You were talking about this jurisdiction, and there are other jurisdictions in the state that are, in fact, increasing some of those setbacks, and for different things. For instance, I was in Warrensburg a couple Mondays ago at their city council meeting, and they had, in addition to daycares, churches, and schools, they included packaged liquor stores and liquor by the drink stores. And it was really interesting to see, because in Warrensburg, we know Central Missouri State, college town, where were all the liquor stores? Well, they were all concentrated right off of the campus.
Mm-hmm.
And the city ordinance that was actually passed, made it a 100-foot buffer from the liquor by the drink. But they did, however, drop the 100-foot buffer from the packaged liquor distribution or liquor store.
They lobbied that because a guy who owns most of the bars down there
Right.
wanted to sell 12 packs at $1.30 out the same window that he sells pizza by the slice.
Right, and I figured as much.
Their
that
idea
somebody-
there,
somebody
knowing
had a
Warrensburg,
connection to the bars.
knowing Warrensburg as well as I do, they're trying to keep a dispensary off Pine Street.
Yeah, and the other thing that I found interesting about Warrensburg's ordinance is they also made it 100 feet from any residential area. A marijuana facility could not be within 100 foot of a residential area. So the city map for Warrensburg went from, this big to like, there were 3 little islands that you might be able to establish a marijuana.
I'd buy that real estate right now. Seriously, I mean, that's a story I heard from Denver, is because of their restrictions on where you can have a warehouse, and there were so many warehouses in Denver, they were suffering economically before weed got legal in Colorado. And some guy had the bright idea, he looked at the map, figured out where the warehouses were that would be legal for grows, and he lined them all up, and then all of a sudden they became worth their weight.
Yeah, I want to put in a plug for this lobby day on January 30th. That's next Wednesday. And one of the ways we can protect our interests and advance our cause is in the General Assembly. We here in Columbia take it for granted that we can run down to Jeff City in 30 minutes anytime. For most people in Missouri, that's a big undertaking, a 8-hour drive in some cases, to go back and forth to Jeff City. But we have the ability to go down there relatively easily next Wednesday at 10:30 a.m. in hearing room number 2. You can find these details on Missouri Normal's website, but if you want to write them down now, next Wednesday morning at 10:30 in the morning, be down there at the Capitol building, the basement level, hearing room number 2, and we're going to be gathering there. We'll be meeting with some legislators who are on our side. We'll hear from them about the bills they have pending. There are a lot of good bills. There are a lot of bills we want to support. There are a couple of bills that we don't want to support, and fortunately it's easier to stop bad bills than it is to pass good ones. But the point is we can really have an impact. We want everybody down there to wear a little gold pin that day, walk around the Capitol building, let them know we're not afraid, we're up front, we're part of this state. I mean, we have just received a landslide endorsement from the voters of this state. We have no reason to be shy about going down there and telling those legislators that we expect them to respect the will of the voters who put them in office and who passed medical marijuana on November 6th. So please join us. We'll really have fun. I mean, I think this stuff is fun anyway. And it's much easier to lobby with a group of people. So we'll have groups of 3 to 6 people that will go up and visit each of their state senators, each of their state representatives. You always get a better hearing from your own state rep or your own state senator, but you can go with other folks to see their state senator, their state rep. And we really have an impact. We really have an impact when we do that. And so, you can get lunch down there if you want, but we're going to gather probably around 3 o'clock in the afternoon over at Aries Pizza right across the street from the Capitol and share our experiences, share what we were told by various legislators, and get ready to do another one. We may do another one the last Wednesday of February, another one the last Wednesday of March. Legislature adjourns the middle of May, so it's a relatively short period of time. They only work between noon on Monday and noon on Thursday, so Tuesday and Wednesday are the only full days legislators work. So those are the parameters, and I really urge you to do it. And our Capitol building is one of the most beautiful Capitol buildings in the country, and certainly one of the most beautiful buildings in Missouri. I mean, it's really a beautiful place just to spend some time. There's some fantastic art in that building. I really enjoy doing it. We've got copies of the bills we'll give you. We'll give you a roster of all the legislators, their demographics, their room number. It'll be easy and it'll be fun. So please join us next Wednesday. You won't regret it.
And details are also on the Midmo Normal Facebook page. So we're pretty easy to find. Hope to see you all in Jefferson City, and again on the first Thursday over at Broadway Brewery, where I hope you'll join Midmo Normal and